Yeah.
You need a refill before you get up there.
Ooh, I might. Just, oh, well, thank you.
Is that enough?
Oh, yeah, that's
Okay.
plenty. Thank you.
There go.
Thank you all for having me down. Speaking of real world, for the first time in my life, I bought a draper head for the combine, and I was so excited. Any of y'all have a draper? Oh my God, it's cool. And then I immediately wrecked it into an old fence post last night, so I'm going to drive to Columbia in just a second and go find a doodad to fix the corn head, or to fix the bean head. Guys, thank you guys for having me down. I really appreciate it. I love speaking about ag law and fence law topics, and have got to come down to Glasgow here pretty frequently the last several months to come down. Chris and I actually, your all's agent, met each other in college, where we were both Chippendales and danced to pay for our tuition. We didn't make a lot, but it was a good experience. Getting started today, when you guys have your books there's actually a tab in the book so that you don't have to remember verbatim or word for word any of the stuff that we're talking about. You'll be able to go back and read some of that material. What I like to start off with, though, however, is this. How many people in here have never played this game? You have never played Monopoly. How is that possible? Okay, this question is directed at everybody but you. That is amazing. So everybody, when you're playing Monopoly, what goes in the middle? Money? Money? How many people say no, money doesn't go in the middle? Everybody agrees money goes in the middle, right? Where'd you learn that? By playing the game. But who taught you the rules of the game? Probably your parents. The rules of Monopoly since the very beginning, the rules state, do not put money in the middle of the board. You're not allowed to have any money, side transactions, any of that. That's what the rules of the game are. And how long have you all been playing this game wrong? And you learned the rules of the game from somebody who what? Didn't know the rules of the game, but they taught you, right? So where I normally eat lunch when I'm out farming has a little table in the back of it. They primarily sell gasoline, but they will sell delicious chicken sandwiches and some less delicious burritos. And it has got a knowledge table. Y'all know what I'm talking about? You all go to somewhere and eat lunch and there's a knowledge table? You'll go in, you'll have heart trouble one day, and they'll prescribe you some medication and a diet regimen. You go in the next day, your brakes are sticking, and they know how to fix that caliper on your truck. Same guy. Knows about brakes and heart medication, knows everything. Do you think that person has also read the law? So that's what we're going to do today. We're going to start with an actual reading of the law so that we're all on the same page and kind of grasp the weirdness that is Kentucky's fence law. So in the very first part of your tab there, anytime you ask an attorney to speak or to talk about literally any subject, the first thing that we're going to talk about is, I don't care if you say cow, because I go over this with my students at UK. Every semester I ask them what a cow is, and the definitions now, I've only got about a quarter of my class can actually give me the definition of a cow. Most of them, they get it down to bovine. Some of them even describe them as lady bovines, and that's about as close as we get. So attorneys thrive on definitions because you and I have to be thinking the same thing or thinking about the same thing to even have a meaningful conversation. So a strong fence, so a lawful fence. That's in 256.010. And between sub A and sub C, this says that your fence has to be 4 feet tall, sufficient enough that cattle cannot creep through it. Then scroll down to the bottom there and read amended 1944. So the last time the definition of a fence was discussed by the General Assembly, it was in 1944. How many people in here have cattle that would walk, literally just walk right over a 4-foot fence? I always tell Chris and the other fence school speakers, the last group of steers I got, and this helped my exit out of the cattle industry, was I thought I got a really good deal on a load of Canina steers, and I had never before that ever considered needing 8-foot tall fence in my working facility. I don't know if these were crossbred with deer or Bambis or, I don't know, rabbits, but those things could jump. So today, 4 feet tall is probably not good enough. The cattle have been bred genetically much taller for calving ease as much as rate of gain. We just have leggier, bonier animals than we did back in the 40s and the preceding time period. There are things in the law that you can go and read like this, the definitions, and then there's other things that have been determined by something called case law. And in case law, that is judge-made law. And some of those things are very, very popular, and people know the name of them. Most case law people have never heard about. Now, hold on, I'm gonna pick on you because you didn't know, haven't played Monopoly. And so did you not have siblings growing up? Well, my kids now have never completed a board game. Usually one will get pretty close and just flip the board over and pieces will fly over everywhere else when they're done. My brother and I would play to first blood. You know, you play the game for a while and then you just start hitting on each other and whoever bled first lost. So inside of this, you have the right to remain silent. Anything you can and do or say will be used against you. What right is that? You got it. Your Miranda rights, right? So you haven't been arrested either. Haven't played Monopoly and haven't been arrested? I don't know if I believe all of this now. You haven't played Monopoly to the end to get arrested for playing against who you're playing against. So you do have things called Miranda rights, or Roe versus Wade, or Bush versus Gore, Brown versus the Board of Education. There are some cases that are so famous based on the topic that was presented. Miranda rights are one of them that led to Miranda rights. There isn't a stellar case in Kentucky that is Kentucky case law for fence. But the judges in the fence law cases that have been brought before them struggled a long time for what is a good fence. And ultimately, in your all's mind, what is a good fence? Well, okay, hold on. You're probably pretty good. Well, what's it doing? Perfect. A good fence, as determined by the judges in Kentucky, is a fence sufficient enough to keep your cattle in. Now, in Kentucky versus kind of the western part of the United States, because if you get people that have traveled a whole lot, we're a fence-in state. Out there, they're a fence-out. So their case law or their tradition is if you don't want cows in your front yard, build a fence to keep the cows out. Versus here, you have a command through the statutes that are in your book to keep your cattle or your chattel on your property. Does that make sense to everybody? So a good fence by the judge didn't want to ever have to get out and go look at fence, right? So the judge has said, if it keeps the cattle in, it's good fence. If it doesn't keep the cattle in, it's bad fence. Think about driving here today, and I don't have my slide yet, but I'm gonna get the one. How many people passed some fence where they thought the cows are only on that property because the cows like it over there? You got some of that. Well, and that's why you're here, right? Is to not have that. The Kentucky fence law really does come down to you have a right and a responsibility to keep your cattle in on yourself. The fence law also only talks about perimeter fencing. And by perimeter, I mean outside boundary line perimeter fence. Everything on the inside doesn't matter. So if you've got some of that bad fence that don't keep the cows in, and the cows want to go out and take a a walkabout in your soybean field or your hay field or something, that doesn't affect other people. That's just a harm to you and possibly the animals. But the people in the General Assembly of Kentucky don't care about that. What they care about is minimizing externalities to others, minimizing the damage that your cattle will cause to other people or entities by them getting out. That being said, the fence needs to be on the property line. Now, everything that I can talk about, we can totally ignore that and just move on with the fence, but I cannot stress to you all enough, the fence has got to be on the property line, meaning what? You need to know where your property line is. And how many people in here know where their actual property line is? You do because you have surveys?
I just bought a farm this past year, and we're going to put up a black fence. So the two brothers, I think goes to that light pole, I think goes to that light pole. I slept on it for about 2 nights. We'll call the survey. I gained a road and about 30 feet with the survey.
Yep. And is your brother?
No, there's 2 brothers.
Oh, 2 brothers. Okay.
I bought one brother's half and the other brother's. I'm going to let you use this road. I was kind of worried about this road. The survey figured out there it was my road.
Yeah.
I gained about 30 feet off of the
Off the other side. Well, the other side of that lost a road and lost 30 feet. So I cannot stress to you when we get into it here in a few minutes when you're talking to your neighbors, if you're going to pick a fight, you better be sure you are right. You better make... Well, but think about an existing fence line with somebody else. And don't. So let's all figure out where our fence lines are. That is easy when you have a survey. It's easy when you have pins that you can actually go find. Can people in here find pins? I know where a pin kind of sort of should be, but some pins get grown over, they get removed. You've been bush hogging and you've popped a tractor tire on that thing 2 or 3 times. Yeah, the cap's gone because it's probably inside your tire somewhere. So you just went back and found that real weird looking piece of metal and yanked it up, or somebody else that was helping you did that thing, so that pin that should be there is gone. Otherwise, fence lines move over the years. My ancestors were really good. We've got a farm that we've been on since 1792 in Franklin County. I don't think any of my ancestors liked mowing or maintaining fence. So whenever the fence grew up real bad, had trees in it, my guys just moved it. Just move it 10 feet over and you don't have to deal with all of that. And over time, some of those fence lines have drifted 40, 50, 60 feet from their original spot. Any of you all have a situation like that? Think about the fields and paddocks that you all mow that's got a real funny looking tree line that exactly is parallel with the fence, but there hadn't been fence there forever. And that's because somebody in a predecessor entitled to you has moved that thing just because it was easier to build the fence where they did. As long as that's internal, that's fine. But when you start moving fence with you and your neighbors, you might actually lose some of that property. It's a theory called adverse possession. There's some elements that have to be met. But after 15 years in Kentucky, wherever that fence is, assuming the elements have been met, that fence line is the new property line, regardless of what the survey or your deed says. So it's not even looking at your survey. It is going to be looking at the totality of everything. Your survey, your plat map, your deed, and the reality of what's out there. All of that stuff should line up and you don't have a problem, but if there is an issue with fence line drift over the years, you might have more or less property than what your deed indicates. Does that make sense to everybody? All right, so now let's look at 020. So I want to go over 020 real quick because 020 is contradictory to essentially the default setting under the law. The default setting we're going to talk about in a second kind of puts responsibility on landowners. 020 says you can bypass or override, so to speak. 020 is the rook card if we're playing cards. Did you play rook? Did you have like a stick or something like a... Well, I did too. That's So in 020, 020 is the trump card or the rook card or the magic star in Mario that makes everything else irrelevant. 020 says if you and your neighbor or, and this is very important, your predecessors in title, whether that, and I say predecessors in title because it doesn't matter how you acquired the farm, through gift, inheritance, sale, anything like that. The people before you or you today can enter into an agreement with the landowner on the other side of the fence, and you can modify who takes care of what. Does that make sense to everybody? So this thing says if you do this and you record it, and you've got to go to your county clerk's office to record it. So hypothetically, you're putting the world on notice or on blast that, hey, I have an agreement with the neighbor. Here it is recorded. It's for all the world to see. I just didn't think this thing up years ago and say, oh yeah, Mr. Jones across the fence and I shook hands about who would do this. There's some actual steps that you need to take. Just be aware if this thing is recorded on your property. I don't think here or over towards Columbia, because I've handled a lot of fence law cases down here. I've not seen one in this region, but south of Bowling Green, I've seen a bunch of these. Out in kind of the Franklin area, there was an attorney in the 20s and 30s that used kind of these agreements in their land deeds for whatever reason. So you've got stuff that's, within driving or striking distance of here, but just be aware if you've got one of these things. Actually be familiar with your deed. Sometimes deeds have these things in there. If you've got an easement, an access easement, a right-of-way, sometimes these agreements are also found in those documents. Here in Barron County, I think if this thing existed, it's going to be in a special little book called a Les Pettis book in the county clerk's office, but we all have COVID and you can't go into the county clerk anyway, but it might be in there. Just go and check that thing out one day. Does that make sense on 020? Yes, sir, Chris.
So I was wondering if I'm fencing, putting in a division fence,
Mm-hmm.
new fence, there's nothing there right now.
Yes?
Do I bear the burden of putting that fence in, or do I share it with my neighbor?
It's whatever you and your neighbor come up with. So here's the deal with what Chris is asking is over in the very next section. Oh, wait a minute. There's 030, then switch over to 042. That's the real meat of the Kentucky fence law. Chris is asking, I've got a fence, I've got a property, and for whatever reason, either because of a new subdivision, a new legal splitting somehow, that you bought one brother out and not the other one on a piece of property. If you have a situation like that where there is no fence, you have one of two options. Option number one is to go talk to your neighbor. And I really want to stress that. I am one of the very few attorneys that is going to push you to never litigate something like this. Because if you ever sue a neighbor, they're going to remember that forever. For generations. Yeah, that will haunt and follow you. Particularly if your neighbor is a cousin or a family member or, God forbid, an in-law. They will never, ever, ever let you forget something like this. What if they're an in-law and then become an ex-in-law? That's even better. Any of these situations can take place. So anytime we talk about fence and maintenance and building, construction, any of that, please maintain or go to every length you can to maintain that excellent relationship with the neighbor. Because right now, if you all have your cows get out on the road, who's generally the one calling you? The neighbors. You think they're going to call you after you've sued them? Hell no. They're not going to do a thing to help you after that. Nothing. So we want to maintain that relationship the best we can. If we cannot, and so Chris's question is, nothing exists, this law creates a mandate or an obligation to both landowners. I would invite the neighbors over for pie, meet them at the fence, do whatever you need to do there to educate them on this. Because sometimes people will dig in for a variety of reasons and say no, one of which is I don't have cattle, but you do. Why am I helping you with your operation? And they may not be aware of this landowner obligation that they have. The backup to that is if all of your negotiations and education efforts fail, 042 provides the blueprint for suing somebody to force them to build fence. They're responsible one way or the other. It's just whether you want to sue them or not. So you've got to negotiate harder than the threat of a lawsuit. Well, if a judge orders the fence built, most of the fence I've ever seen ordered built has been woven wire. Because it's a standard fence, and that's generally speaking what they have. I've seen barbed wire in some cases where the terrain was too rough up and down to accommodate woven wire, or places that there's an actual water gap, maybe down on the creek, but when the creek is really up, this is generally speaking after one side or the other has agreed that yes, this washes out all the time, that they will abandon the woven wire and put in barbed wire just for simplicity of replacing it when it and all the trash ends up, kind of farther down the creek. No, sir. So in here, let's back up one spot because everything else that we have predicated on this is when the cows escape, who's responsible? Number one, the default in Kentucky through some other court cases, some other case law, is that if you own the cows, you are responsible. Period. 030 describes, the one immediately preceding this, says whoever side of the fence the cattle get out on is responsible for the escape. So your neighbor is supposed to be maintaining their part of the fence, and they're supposed to hypothetically be responsible for the cows and the damage they cause when they escape. But I can assure you, if they're your cows, you are going to be responsible. Yes, sir. Sure. How long were they in there for? They ate 33,000 pounds of corn. That's a daily gain right there. You're putting some pounds on those cattle. Sure. Mm-hmm. No. If she's an insurance farmer, she's turned a corn claim in on that. So why don't you start investigating the yield averages for that field versus what she just told you it made? I'm guessing there's going to be a discrepancy in those two, unless the very highest 4 acres worth of yield happen to be what your cattle walked through, and I'm betting you that'll. Sure. I would negotiate that. Sure. When she goes to court, she has to prove that your cattle caused that amount of damage. And I think that that's going to be the biggest uphill battle, period. Sure. No, she's got to prove it. You don't have to do a thing. You can say, nope, I don't think so, or how is this different than the rest of the field? Show, Judge, can you make her explain why this is?
Well, not yet. I've got, and I have insurance this one where I'm just waiting to see what all. Because at this point, I'm almost getting to the point where she's even called my father-in-law, threatened to take him because he's the landowner. But now I lease the farm from him.
The landowner's responsible, so it's your father-in-law that will be responsible for one, but then also for you as the cattle owner.
Okay. Now, what about them? She doesn't own the ground. She tends it. So she gets the 3/4.
She still suffered the damage there.
What about what you were talking about, sharing the responsibility?
The landowner there would be responsible for the upkeep of that fence. Do you know where the cattle got out? Is it on your side or her side?
Well, it's fence is probably 60 years old. It's been dented a million times, but it's where now that would be the property line.
Okay, hold on. We're going to talk about that. All right, so normally, crop damage is incredibly hard to prove or find. What is very easy to prove or find is cow damage maybe on the minivan. Because then there are parts of the cow literally in the minivan or there on the side of the road that can find it. I have had now 3 different occasions in Kentucky where cow gets out, strikes a vehicle, and then nobody claims ownership of the cow. You can see a yellow tag in the police report. You go back there later, the tag's gone. I mean, I don't know, they deteriorate that fast. But I have seen a few cases like that, and while I find them highly amusing, there is still some liability that flows from that. So first of all, for that question is great. So look in sub 6, I believe, in sub 6 of 042, that describes landowners' upkeep and construction responsibilities. So that's when you and I are looking at each other, regardless of if the fence is 6 days old or 60 years old. In either one of those scenarios, the landowner's obligation is still the same. Whether you've got old fence, brand new fence, if it keeps the cows in, it's good fence. If it fails to keep the cows in, it's bad fence. So if we're looking at each other and the fence line is 1,000 feet or the property line is 1,000 feet, when we start at each end, we should meet at the 500-foot mark, right? Or whatever it is. And this is regardless of whether they had snakes, doing the survey or whatever, or there's pins and calls that loop around old features or functions or anything like that. It's 1,000 linear feet, wherever that is. Number one, if you ever step that off, go put a T-post or some sort of visual marker out there so that you never have to think about that again. Because if you've done it once, you will absolutely be doing that again. If you've had that kind of interaction with the neighbor already, go mark it, and that's a very clear visual for everybody that's involved going forward. When I'm on my side of the property line and you are on your side of the property line and we're looking at each other, we are each responsible for the maintenance and upkeep of the fence to our right. So my fence is 500 foot this way. Your fence is 500 feet that way. My left, your right. And that's where it comes down to where the cows get out in that situation is exceedingly interesting. Because it sounds like the whole fence is bad. But okay. Okay, well, shoot, because otherwise we could say, hey, you should have been out there fixing the fence, it sounds like. But that didn't happen there. You can argue things like act of God or something like that. That's a common insurance claim. When fences fail because tree lines shed limbs, anybody with a sycamore, gets to fight that every single year. But there's an additional defense in the law or additional theory called foreseeability. Is it foreseeable that cows get out? Yeah. And so if you get on the stand and the other side's allowed to question you, the other side's going to say, have you ever had cows get out? Can you legally swear in front of a court, oh man, my cows have never gotten out. I've never even heard of cows getting out. Part of having cattle is the thrill of going out at any given time of day and getting to put cattle back in. Chris and Jeremy have teased me before, and I've said, since I have become a row crop farmer, I have never gotten a call at 2 in the morning telling me that my corn was out wandering, walking up and down the road. My corn kind of stays exactly where I planted. I have failed to tarp a semi before, and some of my corn did get out in the road then, and I got a talking to by a sheriff about that. But other than that, you are still responsible, because not only is you've got the fence line obligation, but you've got that foreseeability that your assets could cause damage to others in that scenario. So there in 030, and then again it's going to repeat it in a minute, the first time the cattle escape, essentially the responsible parties pay the damage. So in your situation, it was $2,400 is what she's trying to ding you for. Let's just use that as an example. Let's say cows get out on episode 1 and it is your side of the fence for whatever reason. They get out and cause $2,400 worth of damages. Well, that's what you write a check for first time. The second time that the cattle escape, you now get to write not only a check for the $2,400, but you double it. And that's essentially double and triple damages in the law are additional penalties. It's essentially saying you should have known, look, you've already had one escape, you should have known or should have watched or something like that. Those are granted somewhat rarely, but $2,400 times 2 is not bad. What's 10 grand times 2 starting to look like? 20,000, $250,000, whatever that is of the damages that you caused. And it doesn't matter if the first damage was $500 and the second time it was $10,000. It's second event, you start paying double. The landowners are responsible for the fence to their right. And if you've got great neighbors that are also involved in farming, end of story, right? They maintain their fence, they do all of that. What about reality? How many people in here have the little old lady next door that probably doesn't own a chainsaw or a pair of fencing pliers? That gets to be a problem. What if your next door neighbor is an absentee landlord that's renting crop ground to somebody? Does that absentee landlord realize that they have an obligation under the law to maintain their side of the fence? That's where these conversations and just knowing who your neighbors are is very important. I rent from people who live in Florida. I rent from corporations. So the corporation isn't out there looking at it all the time. So part of my lease agreements with them is if I have an adjacent cattle or where I am, horse farms, I will maintain the fence. That's part of my lease agreement with them, just so all their everything in their court is covered. If they fail to do this, you've got a couple of different things available to you, but you need to talk to these people. Even though they have a full responsibility for maintaining their side of the fence, sometimes they have things that will impede them being able to do so. Number one is knowledge or tools to do the job or do it properly. Number two is they might lack the financial resources to do it. So again, that little old lady on a fixed income, that's next door, she might not be able to run out real quick and pay for a bunch of fencing out of pocket without much of a heads up or a notice on something like that. So you do have other realities that are available to you. And by talking with somebody and engaging with them and talking about the farming and farming operations, you might know that and choose a way, a tone or a voice that you would want to use to engage with them to kind of get what you're after. Sometimes even if the neighbors just pay for fencing supplies, wouldn't you be exceedingly happy? They bought you a few rolls of wire, some staples. I think if you can do that, sometimes you're better off. And then you've maintained that relationship. But 042, the rest of that section that I was reading from just a second ago, this describes the methods for if they don't. If they don't maintain their fence, or in Chris's situation, where he's bought a farm and there is no existing fence line, your situation, and they refuse to build the fence, 042 is the guideline or essentially the instruction manual for how to sue your neighbor. Number one, it says you're going to bring this lawsuit in district court. in the county that the harm has taken place in. That gets really interesting. Anybody got a farm that straddles counties? Hypothetically, you've got to sue them in the county where the cattle escaped. So that can be fun to figure out which county the cattle escaped in. Then you can go there, or sometimes they say wherever the mailbox is, you might have to play some jurisdictional rules or games on that. Mm-hmm. Yeah. The law says yes here in the statute. The common law says they're still your cows. So when we educate them with the fence law, hey, here's where you're supposed to maintain your part of the fence. Instead of that $2,400 bill, how about you let me pay for $6 or $4 or something like that, and then let's go fix the fence. Or, you know what? Fine, I'll pay you your $600, but we're going to go put it towards some fence, right now. So that might change that negotiation that you have with them. But ultimately, the cattle owners are responsible for them. Does that make sense, everybody? Inside, yes, sir.
Like in this situation, where would you apply for your farm liability insurance? I've known a farm credit writing checks in this situation, or not farm bureau.
Farm Bureau, yep. Number one, if you're all running cattle, buy insurance. I mean, it is a no-brainer. I've got $1 million on the farming operation that I have, and it costs $400-something a year through Farm Bureau. My auto insurance is not that much because I have a tendency to rear-end people while looking at other people's crops. I've done that twice in the past 24 months. Farm Bureau will write a check if they determine that you as their client are negligent in that situation. But you're still covered, but you need to tell them you have cattle. That's right. They're going to investigate on that. Yep. She destroyed her own evidence. Yeah, that's going to be.
So unless she's had an insurance person actually go out there,
If she's. That would be better on her behalf. But again, when it comes down to suing somebody, it's whoever the judge in small claims court, because there's no jury, believes more. You just got to be more believable than lady next door and just ask good questions of, what the rest of the field make? What about these 4 acres? You just plant some ideas in there and then say, Judge, I've offered to settle for $600, and I'd say the judge will assign that and roll on because they've got a million other cases just like it right behind it. Yeah, but having a claim and winning in court are 2 completely different concepts. You have to be able to prove your damages in something, and proving that it was your cattle and not deer damage or something like that. So it's a hard thing to do to be a plaintiff and bring a lawsuit. It is not a hard thing to do and be a plaintiff and bring a lawsuit if you're suing your neighbor here in your situation or in Chris's, because in 042 sub 3, look at the very last line of 0 sub 3 there. Yes, sir. Nope. Yep. Well, there's a weird rule now that corporations in small claim, as long as you've got somebody that's either their agent or supermajority shareholder, can represent. It's a weird thing going on with the court. But otherwise, a corporation doesn't have a voice. It has to hire an attorney to speak. But I think there is a small claims court exception for that. But it's open to interpretation. So you've got to ask in your local small claims court division whether they're allowed to do that or not. There was a Supreme Court rule proposed for that, but I'm not really sure where that went. If you think this is boring, go to a Supreme Court rulemaking session I was the youngest person in the last one by about, I'm going to guess, 40, 45 years. Uh, so that was the last one I'll be attending. And yeah, yeah. But you have to tell your insurance agent that you have cattle. You need to make sure that that is a covered event and not a specifically excluded event. For Farm Bureau and most of your more traditional ag insurance providers, that's going to be fine. It's only when you get into weird stuff or off the farm stuff that Farm Bureau might say, hey man, you're not covered. It's a non-cattle example of that, but how many guys have ever gone and helped the neighbor harvest or gone and helped the neighbor spray or something like that? Sometimes your farm insurance ceases the moment you go and help somebody else. The moment that you pick up and go somewhere else without having told your agent and getting something called a rider made available to you, you don't have crop or farm insurance when it comes to that. Yeah, you need to list everywhere that you're farming. So even for your cows, how many people in here have picked up some pasture in a short-term situation? Guys, when I was in college, I did that all the time. I'm up in horse country, and sometimes some of these horse farms will let the back of their horse farm grow up, and they would let you go in there and graze it for free as long as you mowed it when you were done, which was fantastic when you had cattle good enough to go field load back there at the end to do that. But even if it's a one-time, 2-month event to go graze some paddocks that they had, you have to specifically list that location to make sure that you're covered. In 042, it says at that very last line, if the judge finds the fence inadequate or finds that the fence line does not exist, he or she shall order new fence built. So in Chris's situation and yours, there is no fence. Think about how the evidence would look in court. Go out there and find where the line is and take a picture of no fence. Pretty much a picture of no fence will do, right? Judge, there is no fence. What's the other side going to argue in court? Yeah, there is. There really is a fence. He's hiding it from you. It's either there's a line fence or there's not. And that happens very, very frequently in subdivision opportunities like what you're talking about, where they carved the line wherever and it wasn't on an existing fence line. So the judge in that situation will order new fence built. They will order the type and style of the fence, either woven wire or the barbed wire like you were talking about, and apportion the cost between the two. Be aware in this that the judge can say 50-50 on building the fence, where before maybe your portion of the fence was very easy to construct because you had 3 feet of topsoil and it was nice. The neighbor might have rock the entire way. It has to be drilled or dynamited out. There's like 5 rivers to cross. I mean, there's one side inevitably is going to cost more than the other per foot. But when you go to court in a situation like that, the judge can say halvesies on that, and everybody walks away. Also in that, if you've got to bring in a bulldozer or a trackhoe or something like that to clean out everything, the judge can order that done as well for making the surveying of the property better again, and they can order who gets the junk off of it. Because maybe one of the two parties wants the trees, they want the rock, they want the fill for somewhere else. Anybody in here have a track hoe? So I've been speaking with Chris for 3 years now? 4? And Jeremy, I bought a track hoe. I used to say that is the coolest thing I ever bought, but now I've replaced enough hydraulic hoses on it, and those are expensive. Like you can't go to Tractor Supply and go get a 10-foot hydraulic hose that's an inch wide. It doesn't matter what breaks down. The answer is $1,000. It's just one of those weird things. Yeah, it's like a bulldozer. But the judge can order some of that done. Because if you're talking about a situation where the fence is already bad enough, that 60-year fence scenario, chances are you don't have a 60-year-old bad fence and that's it. It sounds to me like you got a 60-year-old tree line grown up with some fence that kind of is scattered in and out of there. Sometimes it is just easier, simpler to start fresh, and with a track hoe they can grab the stuff and they can pile it for whoever wants it, and y'all can negotiate on that stuff too. The other side, yes sir.
I know it doesn't work in all cases, but I've had every place I've ever had, old fences especially, used to always put, like we talked about earlier, the good side of the fence towards the neighbor.
That's a great question. Who gets the pretty side of the fence or not?
And I've got neighbors now that have no idea what the middle is. But all you have to do is walk down the fence line, and you can see there's a post.
Yep. Yep. That's one way to indicate where at least people had a non-documented conversation about it years ago. And I've seen that. I have seen woven wire meet other woven wire, and they switch positions on the post. My dad had to sue some neighbors where a subdivision came in, and my dad offered to build whatever they wanted. So of those 13 neighbors, we have a collection of 4-board plank fence that will end, and then woven wire will start for like 500 feet, and then plank will resume again. One neighbor told us they wanted plank, and my dad built his half of plank, and the neighbor thought, oh my God, plank's really expensive, and they built their half in woven wire after that. My dad built woven wire with people that wanted woven wire, and we had 6 or 7-inch posts, and they had posts that I don't know were just too big to make toothpicks out of or what, but they were the smallest wooden post I've ever seen in my life, to the point that I don't know if they hand dug them, because I don't think a post hole driver, I think they would have shattered. They were that thin. So as long as they keep the cows in, though, that's what's sufficient. So read the other part of that. If you lack fence entirely, then the judge, that's a very easy decision for the judge, right? The other decision there is if the fence is inadequate. So the fence is inadequate if what? Failed to keep the cows in. So to go to court here, you need to document at least one time, twice is probably better, that the cows have escaped. Your Honor, I'm swearing to the court that the fence is no good, and the judge is going to say, why is the fence no good? Because the cattle have gotten out at least twice, or once at minimum, but better is twice. So you've already taken the gamble twice on potential liability to document that the cows have gotten out to begin with. When I first started doing this a number of years ago, I remember when iPhones were just brand new, but y'all remember flip phones? Did they even have cameras? I don't remember now. Maybe. It's pretty hard. And so the judge did not expect you to get out there with an Etch-a-Sketch and draw a picture. But today, if the cattle escape, go find where that was and take a picture of it. Take a picture of the hooves and the escape point and stuff like that. Particularly document it if it's on the other person's side. But on yours as well, you can demonstrate that the fence is no good, and that is good evidence, if the entire line of the fence is bad, that the fence is inadequate. If the judge finds the fence inadequate, they will order new fence built. Yes, sir?
So the farm next to ours,
Yeah, that's what happened to.
we've got 20,000 more neighbors. So we have to replace that fence. We have to negotiate with each neighbor.
Mm-hmm.
Some neighbors have put a chain link fence on their side
Mm-hmm.
around their entire fence. So we've got a gap in places. So they have a picture, or we still have to negotiate with each fence.
One farm, I'm hoping to go cut beans on that this afternoon if I can go find the part that I need. Had 367 neighbors. I'm kind of a peninsula around subdivisions. There is chain link, there is privacy fence, there is 4-board fence, there's chicken coop looking wire that I don't know what that's keeping in or out, but there's a collection of fence. But in that situation, you have to negotiate with 25 different people. If you guys ever find yourself, or your parents or anything like that, wanting to sell off part of the farm for a subdivision, maybe you're going to get a good price, what are you going to do? Fence it before you sell it, maybe, or when you do sell that to the developer, use that O2O language that says, hey, 25 people, you're responsible for the fence forever. Write that in there as part of the sales agreement and contract, and go file that in the county clerk system. So I've done this a lot in Scott County, where I am. I've helped people negotiate or write that into contracts, and usually the developers are so near-term sighted that that doesn't cost them a dime, they're going to sign it right then. So those kind of things can and do happen. But the adequacy of the fence, you have to go into court and prove that the fence cannot keep the cattle in anymore. And if you're successful in that through using the same things or theories we were talking about a moment ago with evidence, then you'll get some new fence built and a judge's order that the other side pay for it. If the other side does not pay for it, that you can go back and you can pay with the court's approval, can pay the entire bill and go slap a lien on somebody else's property. You get statutory interest at that at 18%. My dad has had one for decades on a guy that just refuses to pay that bill. Crazy. Yes, sir. Anytime he wants to go convert his lien into, but it wasn't for a lot of money. It's more of the amusement of I think it was like $1,500 or $3,000, something like that. But it's drawing rate at 18%. I don't know if y'all got money in the stock market. Oh yeah, it's a judgment lien. Yeah. If it's ever sold, it has to be. Yeah. Yeah. Yeah, he has no incentive to go do it now. It's like having a CD at 18% interest. It's pretty great, and it compounds. Yeah, I'd take that too. So on this one as well, you've got some lien language and short title of the law. The next two, the 080 and the 090, come back to essentially it's the same law as the one bite rule in Kentucky. You kind of get like a one-time example. You get a one-time example of liability at a minimum, but after that, you're going to start paying pretty substantial dollars to learn a lesson in cattle escapes. Does anybody have a question in here on that? So you've got a copy of everything. This stuff is written horribly. I mean, this is written really bad, and it's written in a bunch of older language and hasn't really been updated. Oh, I'm sorry. I think you had a question about who can sue. So it's not only the land, it's just the landowner versus landowner. Those are the only two people that have what is called standing in the law to sue one another. But who's eligible for that? Do both sides in this need to be farmers? And the answer is no. In 042 sub 2, it says that one of the two people need to be involved in agriculture. It used to say one of the two parties needed to have livestock, but there was a slight tweak to that somewhat recently. So only one of the two of you need to be engaged in farming. You can't use this thing in your rural subdivision to go force your neighbor to build a privacy fence with you or something like that. But if your subdivision, maybe the back side of your property or the side or something, abuts a farmer, then yes, you still have to pay regardless of whether you have livestock, so long as the other side is involved in agriculture or animal agriculture, then the fence law applies there. So the pretty easy concepts to remember. The fence must be on the property line. I get into this a lot where somebody says, I didn't even want to fool with it. I put the fence 5 feet on my side. Well, that's great until that other person decides they want to build some fence. Now you're going to have double fence wherever that is because the fence is required to be placed on the property line. So people that tuck that fence back in for several feet think that they're gaining something, but they're indeed not. They're getting the joy and experience of building twice as much fence if the neighbor ever forced the issue on something like that. Yes. Yep, it is. The liability goes to the owner of the cattle. The liability also can flow to one of those two landowners on which they failed in that negligent duty to another and let the cattle escape through poor fence. So always the owner of the cattle. Then we start looking at farm owner versus farm owner. But because you lease a piece of property, that doesn't give you legal standing to go step in and sue on behalf of somebody else. Because think about a lot of these farms. I mean, you had brother and brother there. Maybe it's brother and brother, and maybe the next door neighbor that you can't get along with is your landlord's cousin, and you didn't even know it. So you can't be going in and suing cousins on behalf of other cousins without the landlords being involved there. You might be a material witness as to whether or not the fence is good or not, but you don't, just because you own the cattle does not automatically grant you standing in a court. That is a really good question. Oh, Chris.
I just had a question about on a rural county road.
Who?
Property line goes to the middle of the road. Right?
Yes, yeah. That's why I don't.
If I build a fence on my
On your half,
it's not a division fence.
that's correct. So here's the deal on that, and that's what Chris is helping me because I'm leaving stuff out. I'm really thinking about your cattle escape situations. I always check. I also get to be a professor at the University of Kentucky. My very first night ever teaching 15 years ago, somebody left a damn Sharpie up on the thing instead of one of these, and I got to pay for 3 new black or ones of these, and I'd only been on the clock for like 20 minutes. So that was, I always look now. Don't let Expo fool you. It could be a Sharpie. So the property, everyone can always agree, where's the front of a property? Front's always wherever the road is, right? The road's always the front. So we'll put this as the road. So this is neighbor A, neighbor B, and neighbor C. So you've got your 50% point here. So this is just a nice, easy one. Normally speaking, most of you statistically will be neighbors in the front with the neighbor that's across the road. So we're going to call this D. You are actually on a deed, your neighbor is this person. Despite having the road in between you, if this is a county road, you all ever read your deeds? Most of them go to the middle of the road. So in the middle of the road, and sometimes I have seen this quite a bit. Has anybody ever seen where a pin has been driven in the middle of a county road? It's wild. You can literally hear those pins being discovered when they come in and resurface the road. Because that big resurfacing machine will start to sound like a grinder real fast when it discovers one of those pins. So you got a pin here and a pin here. You're going to cause some traffic accidents if you try to fence against your neighbor, right? Not a lot of people want to go be dodging a woven wire fence in the middle of the road. So the default setting in Kentucky is a case that kind of described a gentleman's agreement, which essentially says, yeah, we can't, this is an impossibility to do this. So you fence here. And maybe this is a ditch or a bank or a setback. The county, what they have is not ownership of your property. It is something called an easement. A lot of people call these right-of-ways as well. It's all different terms for the exact same thing. So this area on you is a county easement. So certainly the road, or one lane of the road, or half of a road if it's not a full lane, is absolutely possessory interest of the county through an easement. This area gets to be really controversial because I can't tell you how far you have to hold back on your road. You need to call your county road department. Number one, if it's a county road, there are county restrictions on this. This is a mathematical formula that they can figure out based on how straight the road is. If there's curves and stuff, they want you to set back off of it so for visuals so you can see and stuff like that. But the county not only has the road, but has some additional area beyond the road that is the part of their easement. So your responsibility, if you're running cattle on this, is to run a fence here at some point that you have the entire responsibility of maintaining. Then the converse to that is your neighbor on the other side you don't want to be responsible for maintaining half of that person's fence. So they're going to do their side, you're going to do your side of the road. Yes, sir. Okay. There have been some cases in Kentucky that describe that. And it sure. Think sure. In that situation, if the county has an easement, I would not impair the easement of the county. So I always look at the deeds first. However, easements, as a matter of law, when the government owns these, are allowed to be what is called reasonably enlarged. And you should get a notice on something like that. But roads creep worse than fence lines. How many people on their road, they started building the road, and then you get the gully that's right next to the road. Well, the next time they come through and pave it, they fill in the little gully, and that just has an effect of moving the gully further towards you. But you need to look at their easement first and then contact the road department to see if there's a setback. This is if this is a county road. If this is a state road, there's a mathematical formula in a regulation. I don't know. No, Chris. Everybody's got his email. Chris will be very happy to help you out on that. When your all's cattle get out, part of coming to this presentation, if your cattle get out 24/7, Jeremy's going to give you his phone number. He'll drive from wherever he is and help put the cattle back in, especially because you've made your neighbors mad. Jeremy will be your guy on that. But if it's the state can give you a good answer, and that's calling the state road department. I would always start with the road department, but read your deed first. Get a copy of your deed and be familiar with that thing. And then also with the deed, there can be additional filed easements. So just be familiar with that entire packet of papers, particularly if you bought the farm. At closing, you should have received something called a disclosure statement or a title opinion by the attorney that kind of put all of that together. And I like reading the attorney's title opinions because I don't have to read all that other stuff. It's kind of a condensed little version of that. And in there, it'll talk about impediments, one of which is a road. There's other access easements that the county can have and things like that. I would refer them to the county road department. Read your deed and then the county road department. And then I would go with the larger of the two setbacks. The other reality of doing this, guys, is I don't know about your all's county, but mine doesn't mow anymore. I mean, they kind of pick and choose where they want to mow. So I'm always going to set back not only the minimum, but then whatever my equipment is. So if there is a ditch or a gully, I've got a 10-foot mower now, and the times that I have built some fence, I've mowed. And then we built the fence beyond where the mower, tracks went, just so that I didn't have to go measure anything. And that way, if I needed to move it around or something like that, I could. But this is a minimum number right here. There is no maximum. You can stretch back as far as you want to on that. You just have to be able to maintain and keep the cattle on the road. If you do have a road that is a known bad spot, my parents have one of these where essentially a road tees and goes off like this, and it's on a hill. My parents have built plank fence down to here, and here's whatever wire is left from the last idiot that slid through the fence. This thing, forever we fought this, and this whole field next to my parents' house has been converted into an alfalfa field, just because we know that is a known thing. So think about this in the lawsuit, too. If the car keeps sliding through here and you're saying, hey, man, it's not my fault, the other side's going to come to you and say, how often does the car slide through? And you're going to say, I don't know, 2 or 3 times a month during the winter. Well, then you should know better on putting the cattle in there. So there is a setback provision on this. As normal, I've gone way over time. Chris, thank you guys for having me. I really appreciate it. If you do have specific questions like yours, I like keeping up with interesting lawsuits. But Chris has all my contact info, stuff like that, and feel free to email me anytime you want. Thank you guys very much. Appreciate it.